Our topic today is understanding mergers and acquisitions from small and mid-sized businesses. I'll be giving it to you from a corporate lawyer's perspective. I'm Andrew Stewart, a corporate attorney with experience advising clients through the often complex process of buying and selling businesses. Now, whether you're a first-time seller or a seasoned acquirer, understanding the M&A process and having the right legal team on your side can make the difference between a smooth transaction and a very costly mistake. Today, I'll walk you through the basics of mergers and acquisitions, specifically tailored to small and mid-sized business transactions, and explain why qualified legal counsel is not just helpful, but pretty essential. So, what is M&A? Let's start with the basics. Mergers and acquisitions, or M&A, refer to transactions where one business buys, sells, or combines with another. A merger involves two companies coming together to form one new entity. An acquisition, on the other hand, is when one company purchases another, either buying its assets, its stock, or its operations. In small and medium-sized business contexts, acquisitions are far more common than mergers. Most transactions are structured as either an asset purchase, which is where the buyer acquires specific assets and liabilities of the business, or as a stock purchase, where the buyer purchases the ownership interests, stock or LLC units, from the seller. Now that you know the basics, let's go over the M&A process. So, what does the M&A process actually look like for a small or mid-sized business? Here's a typical step-by-step timeline. First is preparation and planning. Sellers prepare by cleaning up financials, identifying key assets, and resolving outstanding liabilities. Buyers, on the other hand, conduct market research and define acquisition criteria. The next step is engagement and confidentiality. Before any serious conversations, the parties usually sign an NDA, or non-disclosure agreement, and that's to protect sensitive information that's shared. After that, we move to initial offer, or what's sometimes a letter of intent, or an LOI. The buyer submits an LOI outlining the proposed price, structure, and terms. Though non-binding on consummating the deal, LOIs often include binding provisions like exclusivity and confidentiality. And here's where due diligence comes in. There is a deep dive into the business: financial records, contracts, IP or intellectual property, employees, liabilities, legal risks. It's where many deals rise or fall. After due diligence, we move on to drafting the purchase agreement, and this is the meat and potatoes and the main legal document governing the whole deal. It outlines the purchase price, reps and warranties, indemnities, and closing mechanics. Next up is financing and approvals. Buyers may need financing, and lenders often impose their own requirements. Also, board or member approvals may be required depending on the structure. Finally, we get to closing, and at closing, the deal is finalized. Money and ownership change hands, and any post-closing obligations begin at that point. As a bonus step, we sometimes have post-closing steps, and that can include things like earnouts, indemnification periods, transition services, and non-compete enforcement. Now that you know the M&A process, let's talk about the role of legal counsel in all of this. This is the critical part from my perspective, why having a qualified M&A lawyer is essential on your deal. M&A transactions, especially in the SMB space, are really riddled with legal, financial, and operational landmines. A corporate lawyer is going to help mitigate these risks in 6 key areas. Number 1, deal structure. Your lawyer will help determine whether an asset sale or stock sale makes more sense, based on tax implications, liability exposure, ownership goals, that type of thing. Number 2 is due diligence. Legal counsel conducts and coordinates due diligence to uncover hidden liabilities, like pending litigation, unpaid taxes, or defective IP rights. Number 3, drafting and negotiation. The purchase agreement is full of complex terms: representations and warranties, indemnification, escrow, covenants, and closing conditions. A skilled attorney ensures that these terms are clear, fair, and protect your interests, whether buying or selling. Number 4 is regulatory and employment issues. Many businesses need to comply with specific industry regulations, licensing, employment law requirements, especially during transitions. A good lawyer will ensure that there's continuity and avoid violations. Number 5 is risk allocation. One of the most critical legal functions is allocating risk between buyer and seller. For example, what happens if a lawsuit arises after closing? Who is responsible? This is where indemnity clauses matter. And finally, number 6, closing mechanics. Your attorney can coordinate escrow agents, lien releases, consents, corporate resolutions, and all documentation needed for a clean, enforceable closing. So, you've heard you should have an attorney advising you in the buy-sell deals, but let's actually run through some common legal risks in M&A. Here are a few real-world examples of risks that legal counsel helps prevent. Starting with unclear ownership of intellectual property, like software or trademarks, which can derail a sale entirely. Then there are undisclosed debts or liens that can create post-closing liabilities. And we can't forget improper assignment of contracts. Some agreements cannot be transferred without consent, and this is actually a pretty common issue. Another common one is violation of non-compete or confidentiality obligations that can expose the buyer to lawsuits. Finally, failure to comply with employment laws during transition can trigger employee claims or fines, and without proper legal oversight, any of these can turn into costly litigation. Now, let's tie this all together with some closing thoughts. In short, M&A is not just a business decision, it's a legal process. Whether you're buying a business to grow or selling one as part of your exit strategy, the consequences of poorly structured deals can last for years. Having the right legal counsel means you're not just reacting to problems, you're proactively avoiding them. If you're considering buying or selling a business, start by building the right team. Legal, financial, which is going to include tax, and operational. And make sure you're protected from day one. Thanks for watching. If you have any questions about buying or selling a business, or you want to learn more about the M&A process, feel free to reach out.